going to talk about, Todd's going to talk about, I'm not going to talk about who's your client, representation. We're not going to get into that. We're going to talk about a couple of important IP issues. And the first is inequitable conduct. Inequitable conduct, what that means is somehow during when you were trying to obtain your patent, you did something wrong. You did something, you didn't cite a piece of prior art that you knew about. You signed a document that wasn't true. You hid something from the patent office that may or may not have been material. You said you were a small entity, but really you were a large entity. And what that means is just a difference in fees. There's a couple other you said you deserve to be in a special situation because the inventor was over a certain age, or your topic was environmental law, but it really wasn't, right? And so, or the situation changed. I guess an inventor doesn't get younger, but there's some other interesting things in inequitable conduct. And generally, when you went to enforce your patent, the defendant would claim that you obtained your patent via inequitable conduct in some way, somehow. Usually, they would hope that during the discovery phase of the piece of litigation that they could find some evidence of some patent somewhere that you knew about that you should have cited. And indeed, what normally would happen is you'd have a large company, let's say IBM, and in some IBM patent somewhere, a very important reference was cited that would have been material to another IBM patent. And so the defense would start saying, and I'm not saying this is a winner argument, but they'd start saying, look, you knew about it. IBM knew about this great piece of prior art, and you didn't cite it. Truthfully, some of those grew some legs, and through discovery they actually found some interesting prior art. But really, when you got down to it, generally the inventor, the company, the law firm, would have something in their file that didn't quite get cited. And a good example would be foreign prosecution. You'd be prosecuting a case abroad, you'd be prosecuting the same, or generally the same patent in the US, and you forget to point the patent office to the European patent, or the Japanese patent. Or indeed, you take one position in Europe and a different position in the US, which is what Theracent's had to do with. And so what was happening is all these patents were getting blown up, and people were over-citing and citing all the prior art that they could even think of that touched their company, and people built these huge databases and file. And because it took such a pendulum swing to everything was inequitable conduct, if you just thought wrong about a certain reference, a lot of patents were getting blown up, and indeed it just became textbook 101. If you get sued, you claim inequitable conduct right away. Inequitable conduct, they had to have done something wrong. I'll figure it out during the litigation proceedings. And really, all they had to show, all you had to really show was that there was some intent to deceive. And really, that was a very easy standard, because you say, look, that prior art reference was in your file. You must have intended to deceive us if you didn't submit it. Well, that standard really started getting a lot of patents invalidated, and the Federal Circuit took this up in a case called Theracent. It's about a year old, so I'm not going to go into detail on that case. But really, what Theracent said is you must show that the patent owner, to include the patent counsel, you have to show that they intended to deceive by clear and convincing evidence. Clear and convincing evidence is a legal term, but generally, lawyers will correct me in the room, but you have to show more than 75% of the time, right? I mean, if you want to assign a percentage to it, I sometimes say 75%. I'll talk about preponderance, which sometimes I think is 51%. That's the best way to quantify it without going into a long legal treatise. So there's a very strong showing that I actually intended to deceive. So it's not just, oh, it was in your file. You have to now show that it was in your file and you knew it was material, and then you didn't cite it. And the other thing is you have to show that the reference or whatever took place was material. So, but for me not citing this patent, the patent would have. But for this reference, the patent would have issued, right? So you have to show it's that important. It's not just a reference that was important, but the claims as currently written would not have been issued if this reference was considered by the examiner. And as you'll see in some of the cases post there, since you'll see that indeed that's come into play, because in different families of patents, which are basically you might have one patent that has some related subject matter to another patent, and they might end up growing as and be tied together, but have different claim scope, attack different parts of the world, and so as you see in one of these cases, the fact that a reference was considered a not material in one case, the court found, well, it's probably not going to be material here. So some of the cases that are interesting for inequitable conduct, or people are worried about inequitable conduct, the Venice case, which the court held that the specific intent to deceive was the single most reasonable inference. So the court said, the only thing I could imagine by this piece of prior art being in your file was that you intended to deceive. There was no reasonable explanation anywhere that for why that reference was in your file. So I think, in my opinion, in this case, if you have in the file and you have some notes that you've considered it, why it may not be material, I don't think that's a specific intent to deceive. I'll tell you that this is a very subjective test, and what I mean by that is, in the Venice case, they actually found inequitable conduct because the court decided that the inventor wasn't credible. And so it really, the judge who heard the testimony thought, nope, I don't buy anything that you're saying, and so therefore the only reason it was in your file and you didn't cite it is because you intended to deceive. Now that's an interesting case, and I think I wasn't there, so I don't know how the inventor was acting, but I think it's very hard for the court to decide that someone actually intended to deceive. And in this case, there was experiments that showed a negative result, which in truth, when tied to his invention, showed his invention really didn't work. And so he just sort of forgot to cite that. And I think probably when the judge asked him, why did you not cite this stuff that showed that your invention wasn't operable, I can only imagine what he may or may not have said. So the failure to cite is still a viable defense in equitable conduct, and you still can blow up someone's patent for that reason. But the standard is very, very tough. In the Bard peripheral vascular case, this is the case that I was talking about, where in the same family, this material reference was reviewed by the examiner but not found to be material to patentability. And so the court held that if it wasn't material then it's certainly not material now, no inequitable conduct. There's also people blowing up patents for small, almost administrative errors, which are failing to fix this position to make special, small entity status, failing to cite pending litigation to the patent office. And the court has come down and said, no, none of those things by themselves will blow up a patent. Now, you might think that the pending litigation is, ooh, that seems like a big deal. Well, this is a very fact-specific case in which no invalidity or infringement contentions had been exchanged and no invalidity position had been taken. And so the patent office would have found it material had there been prior art references cited in pending litigation, but in this case there wasn't. The ITEXPO case said that they're going to require but-for material or egregious misconduct. So what the Federal Circuit is really starting to say is, we need to see somebody who really has dirty hands, who's really come into this court of equity and they've really done something bad.
Not just carelessness.
Not just pure, not negligent, but they really intended to deceive. And a good example that you might see is someone who knew of a prior art reference, tried to claim around it and thought, oh, that's good enough, and hit it. Or memos, there's always the case out there that there's a memo saying, I don't think we should cite this, this is very detrimental, right? It's still in someone's file. And then the most interesting case I thought was the Delano Farms case, because as you all probably know, the fraud, to plead fraud in a complaint, you have to plead with specificity. And so to bring a fraud complaint, you really need to know your facts. You have to be able to show fraud. fraud is not a term that we allow to be thrown around. Well, inequitable conduct is. We've been able to put that in our answers and said, yeah, and inequitable conduct. Well, in the Atlanta Farms case, the Federal Circuit said, well, I think the moving party needs to recite facts that the individual both knew and validated information and withheld it from the PTO. Wow, that's going to be very hard for counsel to learn about prior to discovery, to be able to get that in play. We'll see how strict that's enforced, but from my point of view, that's going to be very, very difficult. You were just sued, you have 30 days to respond, plus extensions. It's going to be very hard for you to come up with enough information to bring an inequitable conduct defense. And in some of the dicta in some of these cases, you can see the Federal Circuit's just done with inequitable conduct. They say this is just a tag-along claim. It's frequently used, but rarely honest or truthful. It just burns a lot of time and scares a lot of people. And so from my opinion, the Federal Circuit really wants to get rid of inequitable conduct. I don't know what the Supreme Court will do if they pick up one of these cases. I don't know that they will. It doesn't sound, it's not very sexy for the Supreme Court to pick up an ethics and equitable conduct case. But I think for us in the patent field, I think this is going away unless there's some egregious conduct. And I think there's probably the 5% case or the 1% case that there is egregious conduct, but I don't see this as being viable going forward.
Before you go on to the next one, I'm kind of curious about one thing. This is asking you to have an opinion on something or guess, but I keep all my files electronically. So how are they going to find stuff in my files?
Well, with electronic discovery, you may be able to request your digital files, and short of you having a document destruction policy, they just happen to go away or right before suit. Now, if you have a policy for your firm that says once a patent's issued, I go through the file and I remove these following things, and you do indeed do that, then I probably don't have any grounds, unless you knew the suit was coming, to say, oh, Todd destroyed all that information. But and indeed, a lot of people with paper files, when they send them off to offsite storage, would take the left side of the file, or whatever, wherever you put your correspondence, and destroy that, which I think was normal practice at most firms. With digital files, that's not as clear. Are you putting in folders? You have a correspondence folder that you can then drag to a prior art folder that then you can properly destroy, or is it all just one?
So in litigation, you're able to access all my electronic records, Dropbox, my Google account, emails.
I don't know how far we can get down that